Alright, welcome back everyone dito sa latest episode ng Deep Dive. Katulad ng ating pangako, we're gonna have not only one, not only two, but as many legal luminaries, real legal luminaries on our little show as possible para pag-usapan natin itong merits, or some would even say the merits of the latest Supreme Court ruling, which for some was very much welcome, but for some very much controversial. And in that regard, kasama po natin ngayon is former Supreme Court Justice Adolf Azcuna, whose ideas we have actually discussed with other folks, including former Supreme Court Justice Antonio Carpio. Thank you so much, Justice, for joining us.
Thank you, Professor. It's a privilege to be joining your show and informing our people as much as possible on this very important subject.
Maraming salamat. Obviously, we are more than happy to also have you on the show. Just before we get into the discussion proper in terms of your ideas about the Supreme Court ruling, its legal implications, and what are the ways forward, just to get this out of the way, Justice, as you know, this morning lang there were some. Let's just put it, some interested parties who had some very interesting petition accusing some folks who have criticize the Supreme Court ruling as an act of contempt. Just for the sake of our audience, what are the boundaries of freedom of expression, and what is contempt when it comes to the Supreme Court? Does criticizing the result, the ruling of the Supreme Court constitute contempt?
Well, I think it depends on the manner in which the criticism of the decision is made. It should be in the manner that is professionally expressed with due respect to the court. The court is not above criticism, but at the same time, you should be respectful in your criticism of the decision, and not to impute ill motives, for instance, on the part of the members of the court. Just make it on the merits. Your criticism, I think that will be appreciated by the court. Yes.
Now, let's talk about the merits of the case itself. Of course, Justice Ascuna, you have been all over the headlines, and everyone has been discussing about your intervention. For the sake of our humble audience dito sa ating little platform, Justice, may you once again, first of all, what was your expectation of the ruling before it came out? And when it came out, what was your initial sense? And then as you read through the 97 pages, what were the key conclusions that you arrived at, Justice Ascuna?
Well, first, it is what you call a very difficult and important case. And as such, you would expect really that the court would have granted a full ventilation as much as possible of the difficult issues involved on such a case. And I was surprised that the court decided the case without oral arguments. I think that is something that the people or lawyers would expect the court to do on a transcendentally important case. So that's my impression, that what was lacking was oral arguments.
Right, which is a point similar raised by former Chief Justice Panginiban, right? That he was expecting that the process would be a little bit more prolonged. Oral arguments would have been taken into consideration before a final decision was made.
Yes, although it's not for me too late, Professor, because the House is reportedly going to file a motion for reconsideration, and maybe the Senate also. And I hope that if they do so, the court will set the motion for reconsideration for oral arguments. That is possible.
Right. Justice, before talking about what is the next steps with the MR and what could come after to avoid constitutional crisis, to ensure we preserve, trust in the integrity of our democratic institutions and the rule of law. Um, may you share, please, first of all, your argument in terms of the merits of the case itself, because some are saying that it looks like actively a new doctrine has been applied here, that the definition, for instance, of what initiating an impeachment, I mean, for instance, this was the position recently articulated by another former Justice Carpio Morales, like the definition of the initiation of impeachment also changed. Justice Carpio, for instance, on his part talked about yung timeline and the facts of the case and the counting process, and they felt that the Supreme Court did not take the facts of the case proper into consideration. May you share, Justice, what is your analysis of the merits and what you find not necessary, or what you do not agree with per se with the ruling, and what are your worries about its legal implications, if not political implications?
Yes, first, we have to consider the power of the Supreme Court, and in fact, the duty to determine whether or not a grave abuse of discretion amounting to lack of jurisdiction attends the act of any agency of government, a power known as the expanded power of certiorari under the new constitution. That's why I said that the court was well within its competence when it issued those series of questions, because the court is practically given what is known as an inquisitorial mode of action when it acts under its power and duty to determine whether or not there is a grave abuse of discretion. So it can delve into the actively into the determination of the factual underpinnings of the legal issues, which it did, and when it issued those series of questions. Upon the other hand, there is need also to balance that with the idea that the whole project here is about accountability of public officials, and therefore the overarching aim is to make sure that the principle of accountability is maintained rather than frustrated by the requirements in regard to the framework of the impeachment. Those are the parameters for me.
Right. So, Justice, you do not see this as an overreach and a potential, I would say, undermining of the exclusive, basically constitutional mandate of the House of Representatives to initiate impeachment. You don't think there was a judicial overreach when they raised certain questions about the procedures or had certain points of view about whether those procedures were followed?
Yes, I read the 97-page decision of the court, and they discussed the idea of initiation because it is a starting point, because there is a provision in the Constitution that not more than one impeachment complaint may be initiated against the same official within 1 year. Okay, so the word initiated is in the Constitution, but it's not defined. So the court, as an interpreter of the Constitution, can define when a complaint is deemed initiated. In Francisco versus House of Representatives, a Supreme Court 2003 decision, it was ruled that a initiation means that the complaint is put in the order of business of the House and then referred to a proper committee, usually the Committee of Justice. That happens, then the complaint of initiation of impeachment is deemed initiated. That was the rule in Francisco, which was the rule prevailing at the time the present articles were adopted. However, if you read the decision now, it would seem that while it did not abandon Francisco, it is introduced a nuance to that interpretation in view of the peculiar facts involved in this case, namely that there is uh, a lapse of the Congress itself, impending lapse of in this case, the 19th Congress was about to lapse into inexistence as as the 20th Congress will come in. So, given that the articles, the first three complaints were filed sometime in December of last year, and given that the Constitution requires that they should be put on the order of business, shall, according to the court, that's mandatory once they are endorsed by a representative. They, the Constitution requires them to be put in the order of business within 10 session days, okay? Which is not calendar days. So these session days is different from calendar days. And apparently in the reckoning of the court itself, these three previous complaints made it to the deadline. One was put on the 7th, another on the 8th, and another on the 10th session day. So it did not exceed the time frame in the Constitution for inclusion in the order of business. The problem is that that was the 10th day was also the last day of the Congress, and therefore the next step, which is to refer the complaints to a proper committee within 3 session days, would no longer be doable because there was no more 3 session days left. The Congress would adjourn that day. So in view of that unusual circumstances not present in the Francisco case, the Supreme Court said that the 3 complaints which were archived on that day were deemed terminated and dismissed. And therefore, according to the Supreme Court, that consisted of being initiated. And so the 4th complaint, which was made by the Congress under a different mode, adopting it by their own resolution, which does not need to be referred to a committee, according to the Supreme Court, that's already barred because of the existence of the 3 complaints that were effectively dismissed on the same day. So there is some debate there on the priority because actually this 4th complaint was adopted before the 3 complaints were archived and before the Congress adjourned. So technically, the antedated in terms of time the initiation of the 3 complaints. So the 4th complaint was actually initiated ahead of the 3 complaints. So if anything is barred by the 1-year rule, it's the 3 complaints that should be considered barred. So that's the problem, and that's the debate.
Yeah, that's also another question raised with respect because I have 4 different complaints ang pinag-usapan natin. You also made it very clear, Justice, that the Supreme Court cannot be the one to craft the rules to enforce yung articles relevant when it comes to the impeachment process. And after all, the Supreme Court justices themselves can be subjected to impeachment under hypothetical scenarios. So there are some people who are saying that it looks like what the Supreme Court has done here is redefine the parameters or has tightened the noose when it comes to any hypothetical impeachment proceedings in the future against any high official. What is your read on that front? Because some would argue, I think Justice Carpio on this show, for instance, argued that is a form of potential overreach.
Yes, I read the decision again, Professor, and apparently what the Supreme Court did was to apply the rules of the House itself The rules of the House itself provided for certain procedures, including submission of evidence. So the court was applying not its own rules, but the rules of the House when it said that there are certain formalities that should be required. But whether or not those requirements should apply to the second mode is not clear uh, because in the second mode, the the articles, the Constitution says that once article, the resolution is voted by 1/3 of the House, it already consists of the articles, and trial by the Senate shall forthwith proceed. So there is no intervening room for a notice and hearing. So that is my difficulty because I was the one who drafted that provision, that forthwith, and
Oh yes, yes, yes. The
yes,
now it's a
uh,
household
did not
expression.
contemplate hearing at this stage because hearing by the Senate, by the House in plenary, might constitute a trial already, and that would usurp the exclusive power of the Senate to try the case, which should be done, in fact, forthwith. No other thing should be done
Right.
but the trial after the articles are adopted by the House.
So we're towards the latter part of our discussion, Justice Scuna. So what happens next, or what should happen also next, Justice? Because we see some sort of ambiguity from the Senate. Some in Senate are insisting that at the end of the day, because the Senate still has the constitutional mandate, the exclusive mandate to convene the trial, they can just go ahead. I mean, like, thanks for the opinion. Some were saying, well, if a motion for reconsideration is filed, therefore the decision is not final, therefore free pa rin yung handang Senate because that will not be defiance of the Supreme Court. And then some other are saying that maybe there could be other off-ramp or just file it again next year by February. What is your read on this, Justice Ascuna? What should be the next steps and what are the likely? So what is the normative and what is the likely scenarios moving ahead to avoid constitutional crisis and to ensure accountability, which is something you have been emphasizing consistently?
Yes, Professor. The decision of the Supreme Court is immediately executory. So I would think that the Senate should not proceed with the trial because that would go against the immediately executory decision of the Supreme Court. What the Senate should do is maintain the status quo, no trial first, but file a motion for reconsideration with the Supreme Court and argue that they have already acquired jurisdiction under the then prevailing rules on impeachment. And the rule is jurisdiction once acquired is never lost. And therefore, whatever may be the decision of the Supreme Court in the present case, it should not deprive a jurisdiction already acquired so that the Senate can and proceed. In fact, the Constitution mandates that it should proceed forthwith with a trial and and maintain that its jurisdiction continues.
What do you think is the likely scenario moving forward, Justice Ascuna? And what are your worries? Is there a possibility that still a constitutional crisis could be in the pipeline? Are you worried that faith in our institutions could be undermined here? Whether it's the faith in the House of Representatives for those who are critical of the impeachment, or faith in the Supreme Court to those who wanted this impeachment trial to move forward forthwith and as soon as possible. Kumbaga, I'm adjusting the aperture and looking at the big picture in terms of confidence in our democratic institutions. And I don't know what's your stance on this, but a lot of people, including some of your former colleagues, among others, have also raised concerns about, extra constitutional temptations gaining ground if faith in institution is not preserved and restored. So how do we preserve the rule of law and any off ramp the best possible outcome out of this that you think is politically feasible given the circumstances?
Professor, I believe that our institutions will be able to work out a, a solution that will avoid a constitutional crisis because one, there are available remedies still to be pursued, such as a motion for reconsideration while maintaining the status quo. And then there is also the oral arguments that the Supreme Court can order so that the parties will be given opportunity to more fully ventilate the issues in this case. And our people too will be guided from the exchange and all our arguments. So I hope that with a motion for reconsideration and the oral arguments, the motion, the constitutional crisis will be avoided. And people are also wishing that such a crisis will not occur, even as they want the accountability to happen. And so all this, I submit, we also must need to pray for our country. And the youth especially are arranging prayer vigils for peaceful and just solution of this matter.
Just last one, Justice Azcuna, what gives you the optimism, or why should we be optimistic that if ever magkaroon ng MR, the Supreme Court may indeed revisit its initial decision? I mean, do you think it's, for instance, if mas magkaroon ng clarification doon sa technicalities in terms of counting of the days and what you think that could be enough for the Supreme Court to reconsider its decision? Because there's skeptics who say that it's unlikely that the Supreme Court will revisit this and that they're going to stick with this, especially given the degree of conviction that they have expressed in light of criticisms that have been coming their way in the past week or so. What makes you quite optimistic, cautiously optimistic that an MR may actually help the day forward?
Yes, we should not prejudge the action of the Supreme Court in case there is a motion for reconsideration, and even more so if there is oral arguments. It is possible that one or more of them may change their vote, and even if they don't, they could do one of two things: either apply the doctrine of operative facts, which they have done before in similar cases, and say that this new modified concept of initiation of a complaint will apply only to future cases and not to the present case, especially because the Senate had already acquired jurisdiction. That's one, the doctrine of operative facts, without changing their votes. The other is what we have done in similar cases. We say that this case, being so unusual, is the decision in the case is what we call pro hac vice. What is pro hac vice? That means it's good only for this case. For any future case, the court will
Really a
resolve
sui
it
generis case, a totally so.
unfettered by precedents. Pro hac vice, that's possible. So there are many possibilities, Professor.
On that cautiously optimistic note, Justice, because I think a lot of us, whether we have a direct experience or not, at the highest court, like you, a lot of people are wondering like, what is the way out of this? Because if everyone just tries to dig in their position, the ultimate effect may be erosion of trust in our democracy in general, right? And that's why the polarized debates over this is a source of concern. And I genuinely hope we can also learn to agree to disagree and accordingly, of course, move ahead with substantive debates And I was just at the Congress the other day for the State of the Nation address. I bumped into some of people who were part of the impeachment proceedings, and they're quite optimistic that they can keep the fire going, and that if necessary they can refile this again next year. So I think at least that restored my faith in people's faith in our democratic processes. Kasi ang worry natin is hindi lang magpa-ping-pong, everyone will try to impeach each other or question each other, and then we're gonna go down a very dangerous path. On that note, thank you very much to just I hope I got it right. 153rd former Associate Justice of the Supreme Court of the Philippines, Sir Adolf Azcuna. I had to get that one right, Justice. Thank you so much for spending your
Thank
time with
you,
us. I
Professor.
have shared already some of the important analysis you have already bequeathed to us online, and I'll continue to do that for folks who are interested in this. And we hope to continue this kind of conversation with you, Justice, hopefully in person next time. And mabuhay po kayo. Maraming salamat, Justice. Talk to you soon.
Salamat po.
God bless.
Thank you.
Thank you.